Okay.
Just as an FYI, my small human is about to wake up, so he may be joining us.
Okay, that's totally great. We are love to have a small human with you.
Yeah.
Okay.
We are
Just
back.
a heads up.
Okay, thank you. Appreciate it. We are back live, and this is Senate Government Operations, January 25th. And we have with us Damian Leonard, one of our Legislative Council attorneys. And I asked him to join us so he could go over sort of his analysis, legal assessment of the situation with the administration's proposal to move the state retirees into a new healthcare benefits package, namely a Medicaid Advantage plan. So I have talked with Damian about it a few times, and I just wanted the whole committee to hear his assessment of the situation. So you want to take it away?
Sure. Thank you. For the record, Damian Leonard, Office of Legislative Counsel. So before we get started, I just want to make clear that if you have questions about Medicaid or Advantage plans or health insurance generally, that is not my area of expertise. So Amarin from our office or Jen Carvey could come in and talk to you about those and explain the differences and all the nuances of the different plans. What I'm going to talk about is the basic authority of the state around health insurance plans and how that's been managed under our statutes and what you might need to do one way or the other depending on what approach the legislature decides to move forward with. So very generally, under 3 VSA 479, we have some short and clear statutory language that governs this situation. So it provides that a member who is insured by the respective group insurance plans immediately preceding the member's effective date of retirement shall be entitled to continuation of group insurance as follows. And there's two subsections here. The first is coverage in the group medical benefit plan provided by the state of Vermont for active state employees, or B, for a Group F or Group G plan member first included in the membership of the system on or after July 1, 2008, coverage in the group medical benefit plan offered by the state of Vermont for active state employees and pursuant to the following. And then what it does is it breaks down by years of creditable state service what their premium split would be after retirement. So it ranges from an 80-20 split to full cost of the premium for someone who has completed 5 years of service and less than 10 years. So that essentially, there are two key pieces here. For all state employees who were enrolled in group insurance immediately preceding the effective date of their retirement, they're entitled to continuation of group insurance upon retirement in the same medical benefit plan provided to state employees. However, if they started on or after July 1, 2008, their premium split is going to be affected by that. And that was one of the cost-saving measures that the legislature took back 14, 15 years ago now. So that's the key piece. The health benefits are determined, the terms of coverage are determined through collective bargaining. Under our collective bargaining statutes, terms of coverage include, terms of coverage is expressly one of the subjects for bargaining. So it's a mandatory subject for bargaining to the extent it's not otherwise prescribed or controlled by law. So this would be a controlling feature in law here. So the union and the state can bargain for terms of coverage under the health plan. They're essentially bargaining for active state employees because the union, the active state employees are in the bargaining unit. The retired state employees are not. But because 3 VSA 479 says they get the same group health insurance, the union is in effect bargaining the health insurance that their employees are going to have both when they're active and when they become retired. There was an agreement between the VSEA and the state back in 2014, took effect January 1, 2015, to provide what's known as an employer group waiver plan, or AGWIP, and wraparound prescription drug benefit. Again, don't ask me what these things are, because I cannot explain exactly how one of these plans works or what benefits it provides that another plan doesn't. But that was for all individuals covered by state employee health plans, including retirees and dependents, whose primary medical insurance is Medicare. So this would cover Medicare eligible active state employees and also retirees who are Medicare eligible. Importantly, not all retirees are Medicare eligible, and most state employees are not Medicare eligible. But for those who were, they negotiated coverage under this plan, so it applied to both. So arguably this is consistent with 3 VSA 479 because it's covering active state employees and retirees. Yeah, same plan for them. And then for retirees and active state employees who are not Medicare eligible, they're under the standard group health insurance plan. I don't know if this side letter is still in effect. I'd have to defer to the state or VSEA to answer that. So it was under a prior executive director at VSEA and under a prior administration in the governor's office. So I don't know whether subsequent negotiations have rescinded this, but this is an example of a prior instance when there was different Medicare eligible coverage negotiated, but it applied to both parties. Mm-hmm. My understanding of the current proposal from the administration is to do a Medicare Advantage plan just for retirees, and that there are not negotiations or that they have not negotiated, excuse me, I can't speak to whether there are negotiations, but that they have not negotiated a Medicare Advantage plan for current state employees who are Medicare eligible. Correct. So I'm hearing from Tom here from the union that that's correct, that has not been negotiated. So right now, that proposal would be inconsistent with 3 VSA 479 by its plain terms. So they don't have authority to do that under the terms of the statute. Which brings us to really what are the legislative options? There are two options. Well, really three. One, there's a do nothing option. And if the administration chose to move forward, the VSEA or retirees could sue in court to stop that, and a court would resolve the dispute over the plain meaning of the statute, et cetera. Another option is to specifically set parameters around what can and can't be done. And this really is probably the final two options fall into this. One way to do it is to say you can move forward, and this is how you can move forward. So you could do a Medicare Advantage plan, provided it meets these requirements. You could do a different plan entirely. I don't know what that would look like. Again, not my area of expertise. Or alternatively, you cannot do this, and we're going to expressly prohibit that. Mm-hmm. And again, the current plain language of the statute, as I read it, doesn't give authority, but expressly prohibiting it would be a belts and suspenders kind of approach where you're saying, we think the statute expressly says this, but in the event that a court disagrees, we're going to expressly say this in very clear and specific terms. So with either of those approaches, you would likely want to take more testimony as to the particular approach and how to get the legislative language just right. The thing we're concerned about here is unintended consequences. So little differences in the language could create additional ambiguity or confusion. And that's where you would want to bring in Ameren, Becky Wasserman, if it relates to the pensions, specifically Ameren on the health insurance issues. And you could continue working with me to the extent it deals with collective bargaining. For example, we've done in the past, we've directed the state and the union to engage in impact bargaining to work out the details of a broad strokes plan or requirement that we've imposed. So.
Okay, thank you. Senator Norris, go ahead. You have a question.
I do. So basically, I've heard everything from administration doesn't need legislative approval to move ahead on this. And then I've heard legislators say, well, yeah, you do. And then I hear option one is just do nothing, because this was a bargaining unit that both parties agreed upon, correct?
So the reason why the do nothing option exists is because the statute expressly says that they have to provide the same health insurance, which means they would have to bargain for it with the union.
So why would we make any, let me rephrase that. It's already in statute. Two parties there may disagree, may not disagree on this. I don't really understand our involvement in this at this point in time until it's in statute. It's been resolved as far as I can see.
Right. So I think the issue at this point, and I'm being careful with my wording here because I can't take sides in the dispute, but my understanding of the issue is the administration thinks it has the authority to do this. The union disagrees. On my reading of the statute, I don't believe the administration has express authority under the statute to do this. But again, a court could disagree with me. That's certainly happened in my legal career before, and every attorney at some point you've met a judge who doesn't agree with you on everything. But and so I think, yeah, do nothing is an option. The potential downsides to that, and again, I'm not advocating for this, is that you could end up with the state and the union in costly litigation over the issue if they can't resolve it. From a legislative standpoint, the ideal solution is that they get their heads together and come up with something that works for both of them, and then we pass that language through.
Exactly.
But Senator White, do you have a question?
Thank you, Chair Hardy. Under the do nothing scenario, is there any way it opens up the legislature to any liability? I mean, is there a way that us not acting could make the case for the state act? I'm just trying to make sure that we're not opening ourselves up if we're not clear.
I don't think it opens up the legislature to liability, but the courts have in the past looked to legislative intent. In this case, I think the statutory language is pretty plain and clear on its face. Again, a judge may disagree and look to legislative intent. It's hard to draw many conclusions from legislative inaction because there's a lot of reasons for legislative inaction. On an issue, and a lot of it becomes case specific. In this case, there could be arguments that because the legislature believed the statute was clear on its face, it decided not to act.
Yeah, that's pretty clear.
So, but I think at this point, you'd be arguing over the language of the statute more than you'd be arguing over whether the legislature chose to, take the approach of either, enacting language that enables the plan to go forward or the proposed plan to go forward, or enacting language that expressly prohibits the proposed plan from going forward, or some third option where somewhere in the middle.
Thank
you.
Damian largely answered my question.
Senator White. Yeah, Clarkson, sorry, I'm
Okay.
sorry, I looked at you and.
Allison is.
Allison,
Senator White.
I know.
Senator White, and I was thinking, gosh, is Jeanette here?
Yeah. Sorry,
No, it's
I was
okay.
distracted by the
C.
snow. and
Clarkson,
wondering
C.
what-
White. Anyway, we're a team, and we were a team. So I mean, it's either way, it's like. So the governor did not include funding this proposal in his budget. It seems like maybe discussions and negotiations are underway and they are in the works. I think I would hope that at this moment we might wait and see what work is being done between the parties. I think we have done our work. We have it's very clear in statute. They need to be the same plan or negotiated initially, but the same health benefits, the same health insurance. So I think we've done our work. I think we've made the statutes clear. I think at the time, let's let them work on it. And if we need to intervene by expressly clarifying this, fine. But right now, we could just print this out and blow it up a little bit and present it to both of them. I mean, they're clear on the statute, so I would wait and see what happens.
Yeah, go ahead.
Thank you, Chair Hardy. So in my understanding of the argument that the administration is making is that the change isn't that they agree, and tell me if I'm wrong, they agree that they need to have equal plans, but that the change to the plan is in fact equal. So that is the question that I'm still confused by.
So I think, and I don't want to characterize the administration's position here or put the wrong words in their mouth. I think what you're getting to, though, is the question of is the plan, to use the word from the statute, the group medical benefit plan provided by the state of Vermont for active state employees, or is it a substantially similar plan?
Yes.
And I think that's I think the testimony that I've heard, and again, I'm not trying to characterize it, is that it would provide equivalent benefits.
Yes.
But I think by the express language in the statute right now, it needs to be the group medical benefit plan offered to state employees, unless the legislature changes that language. There's a fourth option for you.
Okay.
Yes.
So you could change the underlying statute itself to something that would enable a substantially similar plan, all sorts of requirements and limitations around that, depending on what you wanted to do. But yes, that I think is the question right now, is substantially similar. Does that mean the same thing as the group medical benefit plan offered by the
Yes.
state to its employees? And I would say no, that's a substantially similar plan that offers substantially similar benefits. So, and again, I'm not an expert on these plans, so I don't think I'm qualified to get into the nuances of the benefits themselves. So
Thank you.
And I recognize I may be getting out of your legal expertise here and a little bit more into
Appreciate that.
healthcare expertise, but if we were to do nothing and the courts were to rule that this is acceptable for what the administration is proposing, is there anything binding that insurance company to continue offering the same benefits that are bargained for by the Vermont State Employees Association?
you mean substantially similar? So one would be the whatever contract they have with the state, and two would be potentially the state being if the insurance plan changed so that it was no longer, and this is getting into a very stretched out hypothetical here.
Right, but I do think it's an
Clear for-
important piece
Yeah.
because we could say on its face today, this is substantially similar, but there's nothing stopping that private company from tomorrow saying, yeah, we're not doing that anymore.
Right, so in the hypothetical here, where a court approved a substantially similar plan under the existing law. I think we'd have to look to the court's decision, and then there would again be the question of if you change those benefits that were substantially similar, so now that they were getting more and more different, are they still substantially similar? And I think each time you get into that, you face the same question: is this permissible under the statutory decision? And then in that case, under the court decision interpreting the statutory language, excuse me, I said decision before, but the statutory language. And I don't, so again, I want to be clear, I don't think substantially similar is what's permitted under the express language. If it were, I think we'd have to look closely at the court's decision. Potentially, you'd have to go back to court to have that issue resolved. So the question gets, you end up with the same question each time there's a potential change.
And my understanding is that would be in both directions. So if the union bargain or the bargaining unit bargained for something significantly more than what's currently covered, we'd have to go to court to see if this is still, so it's not just one instance of going to court. It could potentially be every time healthcare is bargained for.
Yes.
Potentially, unless you get a really clear ruling from the court that tells you what it is and the parties can agree on that going forward. I mean, this language would also apply if the union and the state bargained to cut retiree health benefits. Retirees could file a claim under this language too and say, no, we're entitled to the same coverage. So it isn't really even a union or administration thing so much as the statute says same group medical benefit plan provided to state employees. As soon as you depart from same group medical benefit plan, it seems to me that you've stepped outside of your statutory authority.
Which is one could argue is the case right now, because the retirees have a Medicare plan and the state
But he
employees.
said so do some state.
Yeah, so Medicare
see.
eligible state employees are also covered by that, which is why the 2014 side letter arguably falls within the statute. In a way that this proposal wouldn't, because it seems to be proposing different benefits for retirees and state employees. If that were to change and you were to have a new side letter that said Medicare Advantage for Medicare eligible state employees and retirees who are Medicare eligible, arguably you would again be falling within the statute. Because you would have the same group medical benefit plan. This language could probably if there are concerns about being extra clear on that, you could probably clarify this language more to say Medicare eligible employees and retirees can be covered under a different plan than non-Medicare eligible retirees and employees if you want to continue providing the same coverage. That being said, I think there's a strong reading that or at least a strong argument, excuse me, that the side letter was within the confines of the law because it covered both employees and retirees who were under that condition.
Senator Norris, did you have?
Condition.
Thank you. Just, this is gonna be an easy one. Could you just repeat the title and the information you gave us, Amy? Title 3.
3 VSA 479A.
Would you be willing to just send that to all of us?
Sure. Yep.
That'll be better.
I know, Damien seemed to serve here. This is great. Thank you, Damien.
Are there other questions for Damien right now? Before you leave, I want to get a temperature on Senator Watson, did you have a question? Sorry, I forgot about you up there. You're good?
No questions.
Okay. Good.
This is
So
clear.
does this fall, the sort of union and benefit plan part of it falls under our jurisdiction. So I'm wondering, do we want to do anything? Do we want to wait and see? Do we want to get more information and testimony, or where? I just want to get a temperature reading on the committee right now.
I've said my piece.
I mean, I feel like we should explicitly prohibit it. It's clear to me that that's what the language currently reads, and I'm getting, retirees are terrified that this is going to impact them. And by not clarifying, we open ourselves up potentially to multiple times in court and with expensive litigation. So I sort of err on the side of, let's just clarify what the language means and make it crystal clear. We like belts and suspenders, right?
We talked about that the other day. What are your thoughts?
I'm in agreement with Senator Bielanski. My main concern is that I do think that the administration is making a case that I am concerned a judge could see as substantially similar. I think that that's the case they're trying to make, and I don't think that we have it clarified enough for them to completely dismiss that, because that's the direction they're moving in. But I don't want us to start creating language if the administration is dropping this proposal and not moving forward at that. So I want to understand if they are still feeling the same way, and if they are still feeling the same way, I think it's important that we clarify. And if they aren't, then great, we can move along. But
Okay. And Norris?
Full disclosure. I don't want to break any ethics violations. I am one of those Medicare.
You're a
recipients.
You're one of these retirees.
Yes.
mm,
So I
We're
don't know
clear
if
on
I should actually, I'd rather run out of.
I don't know, what does our legal counsel say about that?
So,
And
well,
I suffer from the condition.
I'm sorry,
I'm just,
my language is inarticulate.
it's
this
not, I know you're very
Um,
articulate.
But
Just pulling your leg.
generally with the conflict of interest, I would defer to the Senate Secretary on questions of that. But typically with a conflict of interest, what we're looking for is, are you somehow going to be specially affected in a way that the broader population is not? So for example, because if you couldn't vote on something that you were affected by, you could never vote on a tax increase or a tax cut.
Yeah.
Because everyone's affected by that. Same thing for, general health insurance and other insurance requirements. So as long as you're not somehow specially benefiting or specially harmed by the legislation, you could vote on it. So in this case, because you're like,
You're one of 10,000.
yeah, every other state retiree, then you should be able to
So I
vote.
realize you're not advising me, but I realize that in response to Chair Hardy's question, what I'm hearing is that this isn't particular to me, that I could actually express my opinion on this, or
That, without delving deeper into your situation, that would be my understanding. Again,
over 65, and I'm on the Medicare and I'm on the
Yeah.
retirement, so I just want to put that out there.
Thank you,
Yeah.
I appreciate that. And if you're uncomfortable, you should, I would talk to Secretary Bloomer just to explain the situation to him, just to make sure you're comfortable, but
I think you're fine.
I think you're fine. So, because there are so many, it's not a singular thing. You're one of many.
You're one of a big group.
Yeah.
You just haven't emailed Tanya yet.
Well, having said that, I mean, if you don't think that I need to check with, I don't want any ethics violations.
We're not voting right now anyway. We're
Okay,
just talking
then,
about it.
just off the cuff, I think that we should make sure that we're clear, and I would agree with Senators White and Zaluski.
The whole state.
The whole
Telling
state.
you.
A lot.
Think of France, think of Hope.
I'm
The whole,
gonna make myself a little.
Senator Watson, what do you think? Would you-
I agree that I think adding clarity is going to be useful in this case, especially given, like I forget who said it, but how freaked out retirees are about this potential change. By making that decision, I want to recognize that we'd be taking up time, and we might have less time to do something else. And I mean, that is a concern, right? Because there's so much work that is important and is on our plates. But just given what we've already heard from retirees about this topic, that is a trade-off that I feel okay about. So just wanting to make sure that, you know, we weigh that cost, but I'm hoping that it doesn't take us too long to clarify. But it seems like it'd be worthwhile.
Okay. Senator Clarkson?
Well, I mean, I think they're working on it. So, I mean, and I think retirees, we can email back with a very strong message about where things are, which some of us have already done. So I think retirees know we're working for them and support them fully. But we've done our work. Our statute's very clear. This is not okay, and he can't do it. The governor does not have the authority to do this. I think the statute's pretty clear. So I don't think we have to repeat our work. And I'm happy to email any constituent who is in touch about it. I think we should give it another week and see, and maybe we could get a sense from Tom about where they are with things. But I think they're working on it. I would really love to have them come to resolution together before the legislature has to step in. I don't think we need to step in.
And I agree with that, Senator Clarkson. However, I'm just concerned, is there a timeline we're involved with here?
Yeah,
That's
so
my
let me, I think we can find that out, and we can hear from both the union and the commissioner, I'm getting all of them titles.
The Commissioner
of Human Resources, again, to just clarify where they're at. And I also will, you know, talk with other colleagues in other related committees too. We'll sit tight for now. I don't think anything's going to happen in the next week. So I think we have a little bit of time to make sure we're doing due diligence on it. We will probably ask you to come back if we do anything. And if you hear anything or think of something we should know, let me know. Thank you, Damien.
My pleasure. And
Thanks, that was helpful. And
Yeah.
thank you for sending us the language, because I think constituents would love to see that, know what the scoop is. Some of us have tried to clarify.
yeah, so it's at the very top of the statute that I sent you the link to. So be pretty easy to cut and paste or however.
Yeah, which is what we'll do.
Yeah, so I certainly am sending constituents language, but I know that yesterday the administration at their press conference did say that they do still plan to move forward with this Medicare Advantage plan. So it does sound like they're still on that train.
Yeah, that was a
Oh,
indication
that's
I got.
Too bad, I hadn't heard.
Yeah, so we'll come back to this if we need to. It's good to get a sense of the committee, and I need to talk to a few other people first, and then we'll come back to it. So I think.
So does this come out as a number bill or a committee bill?
Committee bill.
If we did anything, it would be
Committee
a
bill.
committee bill, because there's not a bill in our wall about it. So we still are in the window where we can do committee bills, but.
You could still request it as an individual bill.
Oh, yeah, we could do that too, but I think.
Sounds like it would be a committee bill.
Yeah.
Yeah, I mean, if it's a committee bill and you vote it out, it's gonna move faster than if you put in a
Correct.
request now.
Oh.
Just
Given we're in a long line if we request another bill draft.
gonna say,
We're hip.